Hello and good afternoon, everybody. This is Bernard Wolfsdorf. I am an immigration lawyer here in Los Angeles, and joining me today, two of our resident panelists, the esteemed Columbia Law School graduate, Mr. Jor Law, corporate and securities lawyer. Jor is going to give us a very interesting presentation today on structuring case studies in both the direct and regional center context. And Mr. Michael Gibson, EB-5 Info, thank you for joining us, Jor and Michael. Michael will be addressing some interesting issues, one of which is escrow, and the other one is EB-5 insurance. So we are adding some new issues for today. In addition, we will be, or I will be, analyzing the Immigrant Investor Program Office, IPO. I will be reviewing the recent stakeholder call on September 9. Most of you probably were there, so I don't want to repeat exactly what it is that was discussed. What I'd like to do is provide a little bit of analysis for you folks. What exactly does all of this mean in real terms, as opposed to simply repeating what in fact was discussed during that call. My panelist, Mr. Jor Law, will be leaving a little bit early, so if you have questions and structuring related questions, please remember you can type in your questions and I'll try and get them to Jor and have them all answered. Michael Gibson, I call him Mr. Due Diligence. He is really the expert when it comes to analyzing projects and pitfalls. So if you've got questions that you'd like to steer to him, please do move forward. I have, just so you know, far too much material in today's webinar. We're always trying to make sure that these webinars are interesting and there's new and topical information. But we probably have too many slides, too much information, but I will nevertheless distribute the PowerPoint to all of you, and you may have some questions. We have not yet scheduled the date for the next webinar. I will remind you that all of the webinars that we have previously done are in fact recorded and available on our website. It's not easy to find them, but if you just click past webinars, they're all up there on a variety of topics. So if you're not able to hear it live, you can listen to it at your leisure by clicking on to the recording on our website. So thank you everybody again for joining us on our webinar series. We've had a very good turnout again. We will be jumping back and forward with the slides. I do apologize to you all for going backwards and forwards through the slides, but let's call these webinars somewhat organic, maybe a little bit dynamic, as I try to integrate the various topics that my colleagues will be covering as well. So here we go, folks. We do seem to have pretty much everybody on board. Again, the specific initial focus is the September 9, 2014 USCIS stakeholder call with the Immigrant Program Office Director, Mr. Nicholas Colucci, and many of his key staff. Was really very interesting. We also got to meet the new Deputy Chief, Julia Harrison. Julia is from operations in the Seattle office, and Mr. John Lyons, Division Chief for The Economist, was also on board, as well as several of the new supervisors in the Immigrant Programming Office. What do we have here? This is a little bit of a plug for my firm. It does have my contact information, Bernard at Wolfsdorf. Feel free to email me questions now or in the future. There's our website. There's our telephone number. This is what they call an unabashed plug for myself. All that silly stuff about being who's who, lawyer of the year, blah, blah, blah. Not so important. Disclaimer, so this is so you can't sue me if we make a mistake. This is not legal advice, blah, blah, blah. We only have 2 lawyers online. We do not give legal advice, but that is what they call CYA that is being added. So, okay. Here we go. Immigrant Investor Program Office. You notice they've dropped one I to be IPO, so they're really cool using the IPO designation. Gosh, I just semi-choked there. Please pardon me. Choking on my own bad jokes. So this conference call was really quite interesting on September the 9th. The IPO now has 83 staff members. I don't know if that's a lot. It sounds like a lot, but with over 10,000 cases in the pipeline, that's just 526s. I can just imagine how high those 10,000 cases would be. Since the ELA system isn't working properly, I think if you stack them top to bottom, and they're about 1.5 feet each. Tao, my assistant here, can do some math. It's probably about 1 mile high versus a pile of 526s there. So they've got a lot to go through. And, you know, by year end, they're going to have 110. That doesn't sound like a massive increase to me, considering that 526 and 829 adjudications are quite complicated. And the 829s, the removal of conditions, that's transitioning. Now I went and used 2 I's to the IPO as of the end of this month. Gosh, let's stop and think about that for a second. There are thousands and thousands, estimated another 6,000-7,000 829s coming up for adjudication. Those are also going to go to the IPO in Washington. So this team of 100 folks have got to adjudicate you know, some, what is it, 15, 16, 20,000 cases, each one of them 1.5 feet thick or so. There's a lot of work that this office has to undertake. And as a result, we are now seeing increased processing times. Now, I have some comments about these processing times because it seems that we're just not getting adjudications. This office does file high-volume 526s, so we seem to see some kind of pattern, lots of receipts coming in, but the cases, and this 526 adjudication time, whether it's 13.3 months or 13.4 months, it looks like it's, oh my gosh, it's so precise, exactly 13.3 months. You know, babies are born at 9 months, and if it's 9.2 months, then you panic. So one gets the impression that 13.3 months is a real yardstick. It's the equivalent of 9 months to give birth. No, no, no. 13.3 months is an average time. It is not the exact time. I get this all the time from a client. Oh, my case has been pending 13.3 months. You know, that's the point at which it lands on an officer's desk. And you can do a follow-up, and you're going to get this response, which is, sorry, it's under review. Or as Director Colucci very clearly indicated to all of us, you know, please stop doing these inquiries. Those of us who are immigration lawyers know how frustrating this is, because you're trying to get your job done, you're trying to get your work done, and somebody is shooting off an inquiry every 2 minutes. Where's my case? Where's my case? Where's my case? And so, quite frankly, 13.3 months is not accurate. And I've got cases which are 4, 5, 6 months past this time, and you do inquiries and no cigar, no response, sorry, you know, under review. And one more very important thing. My understanding of the rules are that if an RFE has been issued, a request for evidence has been issued, or even a request for clarification, the new 10-day email thing that we're getting, that stops the clock. So if it's an additional 3 months that you take to respond to that RFE or request for clarification where you didn't respond within 10 days, that turned into an RFE, add that to your adjudication time. Now, the 829, which is 7.6 months, again, I'm going at a fairly advanced level today. I'm assuming that many of you are quite seasoned. I apologize, but I want these webinars to be focused both towards the entry-level practitioner and the seasoned practitioner. So sometimes we're just going to mix them up and not exactly explain what is an 829. Sometimes I will. The 829, of course, is the second stage application filed 21 months after the issuance of the green card, conditional green card. And according to the IPO, those are taking 7.6 months average. I have to add the word not 7.6 months. I'm not trying to be silly or facetious. The simple bottom line is by statute, that is by statute, and, well, it could be by regulation, but statute and regulation, at least it's in the regs, the 829 has to be adjudicated within 90 days. 90 days and 7.6 months are not the same. The reality is that they are taking a lot longer, but we do understand that the Immigrant Investor Program Office is getting itself up and running, and that's taking some time. The 924, we just got one approved in about 4 months. Now we see a report of 7.1 months. That is to get your regional center designation or possibly an amendment. We are seeing some of them go through faster than this. So I don't know whether this slightly increased time is a pattern. We were seeing 3 or 4 months on relatively straightforward. Now we're seeing 7.1 months. So the IPO mentioned that they are not following FIFO, first in, first out. It's supposed to be project-based, and we have seen some of that, that when a particular project sort of gets cleared, we start seeing batches of approvals coming in, which is nice, makes a lot of sense. Also raises my own little personal concern that in the transition from the California Service Center to the IPO in Washington, are we going to see new issues? The California Service Center, we used to sometimes complain that they were very tough in adjudications. Now we've got a new set of examiners, some of the same folks, but we have a new team in place with a new sophisticated group of economists and business analyst folks. Maybe there's a whole bunch of new issues that we're going to have to be ready for. And we are seeing some signs that projects which we had approved from the CSC aren't moving that fast out of the Washington IPO. So that's a pattern that we're seeing at the moment. But the good news, at least, is that it appears that they are using the same office on each new commercial enterprise project to the extent possible. The other information that was mentioned at the September 9 stakeholder call was the fact that they are in fact moving, but for now we use the same street address for mailing in Washington, but that will change shortly, so be on the alert. Nothing like mailing a package to the wrong address in order to get yourself in some hot water. The IPO mentioned that they had substantially increased adjudication. Again, summarizing from the September call, 300 actions in July 2013, 400% increase 1 year later. That is certainly admirable. The word actions, of course, presumably includes things like RFEs or denials. Not necessarily approvals, but certainly a substantial increase. But what this is as well is not just an increase in action. The 400% increase adjudicatory, if that is the correct word, actions means one thing. Question is, how many more cases are we seeing? And the numbers that were thrown out, which weren't really a surprise to all of us, but were pretty substantial, really said something. The first 8 months of 2014, we're averaging about 1,000 cases a month. So some 8,000 petitions filed in the first 8 months of the calendar year. That's a lot of petitions. And then suddenly in July 2014, this is a staggering number, 1,200 petitions filed in 1 month alone. Oh my gosh. That makes me think, in 3 months, that is only 3 months of filings. At this rate, we would use up the annual quota. Let's see if this math works. That means that we actually need 300 to 400% increase in the number of visas to cover all of these petitions. So if there were 1,200 filings and we have an 80% approval rate, that means about 1,000 petitions getting approved. That means we need at least 25,000 visas to meet this demand. Now, I have the privilege of sitting on the AILA Board of Governors meeting, and I was in Seattle for the AILA, American Immigration Lawyers Association board meeting, and we were talking about comprehensive immigration reform, which has obviously failed in Congress, not going to happen, and President Obama has boldly stated, unfortunately not boldly acted yet, has boldly said that he's going to do administrative relief. And you never know. I have great respect for our president. He hasn't always acted boldly, however. On occasion, he has. Is he going to act boldly on immigration? The million-dollar question. I think he's going to do something. I really think he's going to do something, and he's going to do it in November or December after the election. I think he's got nothing to lose other than the fear at the moment that they would lose the Senate, that the Ds would lose the Senate if he really upset 9 of the so-called swing states, which could go to the Republicans, and this is the reason he's delayed it. But to put it in a one-liner, the question is, will that include a critical interpretation of 10,000 investors as opposed to 10,000 family members? Will he drop the derivatives? I understand that the Department of Homeland Security, USCIS, the White House are all supportive of this interpretation. The statute refers to 10,000 investors. Scratch that. The congressional record refers to 10,000 investors. There was a change in the Immigration Act of 1990 that allows for this potential interpretation. That's George Bush's senior bill, George Bush Sr.'s bill, which created the EB-5 program. And there is talk that we will see some significant administrative action coming from the White House by the end of this year that may in fact resolve the problem of family and employment backlogs. So this big anxiety that we all have about the China cutoff date, which should come up in May 2015 with a 2-year wait line, that may not be a problem if this new interpretation is in fact adopted by the White House. And my feeling is that President Obama has the authority. Immigration falls under the executive purview. An executive order, in my opinion, will be issued. Will President Obama be bold enough to solve this problem for EB-5 investors? And that is really Chinese EB-5 investors, because others will not be impacted. And the answer is maybe. And of course, there would also be the other categories, family and employment. So the question is, because I don't think he would act only for EB-5 investors, but possibly for family, provide relief for family, immigrants, and other employment categories, first, second, third, and fourth preference categories, as well as the employment-based fifth preference category. So that is some of the news. The other big issue that was mentioned, and for those of you, 924 reporting time, there's been some ambiguity about the role of the 924A. Clearly, if you have a regional center or regional center client that does not file in a timely manner, they're going to get a notice of intent to terminate. We have all these acronyms. The new one is NOIT, N-O-I-T-T. We have N-O-I-R, notice of intention to revoke. Now we have a notice of intention to terminate. It used to be called a NOR, N-O-I-R. You also have a NOID, N-O-I-D, notice of intention to deny. Oh my gosh, all these crazy acronyms. The bottom line is if they start with an N-O-I, it's not good. Simple bottom line is if your regional center has not been active, you really need to explain why and explain how your regional center plans are going to help economic development because as you can see from the statistics, over 50 NOITs were issued, 29 for people that didn't bother to file, and 24 for others, possibly people who filed late or inadequately. So simple bottom line is, please remember, these have to get in. Question, of course, is what are they going to do with this information? Is it going to be analyzed? Is it going to be published? We don't quite know exactly where this is going to go. So I have a few other topics here, portfolio investments, that were discussed. That's actually in an earlier IPO. I'm going to loop back on some of these because I want to bring in my co-panelists. This topic here of escrow holdback provisions was discussed at considerable length, and I think I have some useful slides here, but since my co-panelists, Mike Gibson, had addressed this, I want to have him tee up and lead on the issue of escrow holdback provisions, and I'm going to jump into his slides and fast forward through my own, and if we have time at the end I'm going to loop back. Sorry folks, I never exactly follow the slides. I try and make this a little bit logical and to factor in the contribution of my guests. So I may loop back to these. This is also from the February 2014 IPO Q&A about bridge loans, bridge financing, and some very, very valuable information with regard to when, in fact, bridge financing may be accepted. But the bottom line is it has to be initially contemplated, for example, maybe used to refinance, provided you can show it was initially contemplated. That is so important, that critical determination. We also will briefly touch on redemption provisions. I might ask my colleague Jor, who's going to focus on structuring questions, to touch on some of these topics that we will loop back on. Sorry, I'm doing a teaser here with regard to the content. It's just that I'm conscious of your time. This issue also of non-profit projects came up in the February, just so you know what's in the PowerPoint here, which will be distributed after the presentation, and also hopefully we'll loop back to cover some of these topics. This is a direct, I'm just lifting this directly from the published Q&A of USCIS, so don't really like reading PowerPoints, but we'll try and summarize them for you as we go down. The topic of deference has never been more important in my mind, only because when it first got sort of formally published in the May 30th memo, we all jumped up with excitement, some sort of consistency in decision making. The big question in my mind is the IPO in Washington going to provide deference for some of the CSC interpretations? Because for better or for worse, we got to understand what it is the CSC wants in some instances, and the question, of course, is will the IPO in Washington come up with new interpretations? So we'll come back to that. Clearly, on hypothetical projects, there's no deference, but that, of course, is different if you have a specific detailed plan which has been approved. So the question of regional center range, this also came out of the February 2013, scratch that, February 2014 IPO published Q&A, and very, very important definition to evaluate. Is it will, there's your buzz line, buzz phrase, will it contribute to the supply chain and labor pool of the proposed project? That's your analysis. That's the economic analysis in terms of what is the regional center's geographic range. This is the issue of, you know, you get approved for County A, and to what degree can you move outside of that particular county as designated in your regional center. Now there's a new project, and these issues are really quite clearly answered to some degree. Here's a magical word that you need to really look at, is contiguous. The regional center can operate outside its geographical area provided it's in a contiguous to the approved region or approved county. So we know what contiguous means. Those of you who don't, Canada and Mexico are contiguous nations to the United States. We have a common border. That's what makes them contiguous. I'm sure all of you know the word, but it's pretty logical. It is the requirement, and factoring in the prior explanation together with the word contiguous gives you some idea of what your expansion framework is. So here we go onto escrow, and I'm going to hand the mic over to Mike. Excuse the bad puns and the bad jokes. So Mike will take the mic. That's Michael Gibson. In a minute or two, I wanted to just do 2 quick plugs. For those of you who are active in the area, you all know this, but the IIUSA conference will be taking place in San Francisco October 22 to October 24. If you're interested in this arena, you really need to get up there, not only because San Francisco is a fun place to be, but October 22 to October 24, everybody's going to be there. There's going to be 750, 800 people, the regional centers, some of the agents, escrow folks. I mean, everybody will be there. It's a party you can't miss. 2 or 3 days. I have the privilege of doing a keynote panel with Charlie Oppenheim on the topic of China cutoff and China visas. So look forward to seeing all of you. Come and say hi if we haven't met. I know many of you by name, but please come and say hello, and you can get to meet, I assume, will be there. I don't know if Michael's coming as well, but please feel free to join us. Sorry, I'm just looking at messages here, making sure there's something about you may be experiencing degraded quality. Sound working correctly, sir? So plug number 1 was for the IIUSA. What happened to the slides there, Mr. Tao? We need to go back to, sorry, there we are, to this side. So plug number 1 was IIUSA, October 22. Plug number 2 is the Hong Kong Immigrant Investor Seminar That is November 11 or 12 in Hong Kong. I'm going to be speaking there as well. That is a broad-based investor conference. If you've never been to Hong Kong, pretty exciting city. And, you know, good opportunity to get off to China. So if you're planning, I know there's another one in Beijing at the end of October. I spoke at it last year. Not quite sure where that one's going. I'm probably going to skip that one. Can't go to all these seminars, but the IIUSA conference in San Francisco will be big. This one in Hong Kong, I guess it's the first time I've attended it, but looking forward to joining that particular panel. When we send out this PowerPoint, I will put more details, including registration information for both of those conferences with the PowerPoint that we'll send out in case you're interested in following up. So Michael Gibson of EB-5 US Advisors, eb5info.com. Michael, talk to me about escrow. We had a lot of discussion. I hope you got to listen to the September IPO discussion. Where are we going with escrows, Michael?
Yeah, thanks very much, Bernie. And first of all, I have to wish everybody on the call a very happy Shana Tova, Happy New Year to all of our Jewish listeners. And I say just Happy New Year to everybody, so, you know, take it if you can. Yeah, escrow is interesting for the people who've been part of the industry for a number of years. You will remember when 526s were getting approved in 30 days, and that was not too long ago, just 2 or 3, 4 years ago. You have seen, though, recently, in the past year or two, those adjudication times increasing substantially. I think in some cases we heard well over 2 years. They seem to have improved a bit on the efficiency, and they brought that down to about 13 months or so, plus or minus. But it's still causing a big issue for the developers who do not want to wait for the capital. So I'm going to just address the risk component because as an investment advisory firm, that's all we really can counsel on. I'll leave it to the immigration attorneys to discuss the legal provisions with the redemption agreements and what they were discussing in the USCIS call. But from a strictly risk point of view, risk to the investor, risk that they may not get their I-526 approved in a project which does not have escrow or has some sort of a reserve account which it does not sufficiently cover, what happens? And so this question is for the immigration attorneys who are filing I-526 petitions. Should your clients invest only in projects with escrow or without? And our take on this is it depends. I use a famous line Jor uses all the time in securities discussions. It really depends. And what we look for is the timeline of the adjudication of the 526. So in the case where 526s are going to take more than a year, is escrow important? Well, it is if you are in a project which is going to fail. Now, you don't know at the beginning that the project is going to fail to meet the conditions imposed by the 526. That can only be determined at the time of the adjudication and the notice. But in all of the projects, there is a risk that it could be denied. Is that going to be a problem? Again, it depends. Where we look for is if the project is going to be denied, do they have sufficient reserves to meet the redemption of one or two investors or all of the investors involved in the project? From our standpoint, if the project can be developed and operational before the adjudication, meaning if the project is slightly smaller in scale and it can be up and running, operational within, say, 12 months, the issue of escrow is not that important because at that point, what you can do, let's say the developer encounters a complete 526 denial on the whole project, a NOID, where the RFE could take, you know, substantial time and resources to challenge. At that stage, if the asset is completely developed, or even let's say it's 80–90% developed, going to a bank and saying, listen, we need to borrow $5, $10, $20 million, whatever the EB-5 component is, to repay the equity investors is not going to be that hard for them to do, because, as we know, the risk in the construction and development occurs at the beginning, not at the end when they're getting ready to CO. So for our clients, when we look at a project, we want to look at the scale, and we want to see, is this an extremely large project? Is it going to take more than, say, 12 to 15 months to complete? If the answer is yes, then escrow becomes more important, because in the event where you have a complete denial on the project, the reserve is usually not going to be sufficient to cover the payback, and your clients may be in this project for another, who knows, another 6 months, a year, maybe longer, until they do CO. So for the attorneys who are looking, you want to look at the scale and timeline, the development timeline, to determine, is escrow going to be necessary or even required? Because even if they put in a partial escrow redemption, say a 10 or 20% holdback reserve, that's not going to be enough if the entire project is given a NOID.
Michael, that is really critical information when we reflect back on the Chicago project, which was, somewhat of a nightmare. Thank goodness there was an escrow, and people were able to get their money back, or most of their money back, and perhaps not their admin fee. But what we're looking at today is there are projects, $250 million capital raise, $500 million capital raise, staggering amounts, which are going to be very difficult to completely sell out. And, it seems to me that the majority, even when we have escrow now, the majority simply have a 10, 20% holdback for denied cases. It seems to me that the kind of protection that a lot of investors have today, I'm talking 2014, 2015, is not as good as it was 6 to 12 months ago. Is that accurate, or it really is project by project and the analysis has to be done on an individual basis? Sorry, that was such a long question.
No, you brought up a good point, Bernie. The scale, what we're seeing here is that in certain markets, the scale of the projects is increasing substantially, whereas even just a few years ago, I would say the average issuer or offering was about $25 to $50 million. Nowadays, it's common to see over $100 million. And for those large-scale development projects, first of all, from a purely risk standpoint, if all we're discussing is the risk of either the job creation or the return of capital, bigger is not better. There's no question, even if you have developer equity and bank loans, and because simply the timeline to develop these assets is so much longer than, I'm going to use on the other extreme example, let's say a Subway franchise restaurant where you could be operational in a few months. In that case, the jobs are created, the asset is cash flow positive. It may even be profitable. It's hard to say what the stabilization period is on the asset, but certainly they're going to be earning money, hopefully enough to repay the investors at term. Whereas in the large-scale projects, where you're looking at development timelines, 2, 3, 4, 5, 6 years down the road, a lot of moving pieces. Forget about just the man-made events, including a tax on the homeland, or union actions, or changes in the market. You have natural events, hurricanes and so on and so forth. Anything that could delay the job creating aspect of the asset, or the ability for it to earn capital and repay the investors, is going to be a risk. And so you're right. I think the size and scale of these projects would be of concern if I were an investor. I don't think bigger is better. In China, they love big projects because they can put a team of 200 or 300 salespersons behind that and sell it and generate huge commissions. But for the individual investor, bigger is definitely not better.
Mike, recently we're quite fortunate in our office. We have some financial people who really can kick the tires and give me some guidance. This, of course, is your area of expertise. But I was talking to one of our financial folks recently, and I was talking about, well, look at this developer. This is a multi-billion-dollar company. This developer's got billions of dollars, and the expert in my office said to me, you know what? You really got the wrong analysis here. How much money that developer has is completely irrelevant, because they're not necessarily going to put their own money in to cover potential losses of the investor. The critical question, and the sole critical question, is what kind of collateral is there for that particular loan? And that was the analysis that I was fortunately, since I'm thinking, you hear all these big names and big name developer and big name company, and oh wow, that's amazing, so this big company is going to put all their own money into a bad project. And I was corrected and reminded that the important issue is what sort of collateral is there in fact assigned to this specific loan if the deal goes bad. Michael, can you comment on that? And is that the correct analysis?
Sure. It's a great point, and I'll give you a quick story. When I first joined Citicorp, the investment bank, in '86, I remember I was working offshore emerging markets, but I remember in New York they were giving out loans to all of these name brand large scale developers, and this was the late 80s, early 90s, and they were financing just about any kind of project that you could imagine, and the bank was very careful in its credit analysis to determine these were adequate risks, they were good risks, and they had collateral. But the market turned and interest rates shot up, and a lot of these developers defaulted, and they simply walked away from the asset, where Citibank then became one of the largest landowners in the city of New York. And that was the last position it wanted to be in, because it was assuming these assets, and it didn't want to be in the business of owning real estate. So for the purpose, again, of a risk analysis, the question of collateral is important, because when you see the structure of these offerings, typically the limited partners are put in to these special purpose vehicles which may not have access, in fact, oftentimes do not have any access to the developer's general pool of assets. So what they're going to have some position in, perhaps, maybe not, is in the asset that's being developed. And if that asset, for instance, let's look at the example of a mixed-use development which has some residential, some retail, some commercial, huge project, say $500 million, and you've got a lot of bank loans in there, you've got other maybe private equity. Typically the limited partner is going to be in a very poor position, maybe last, maybe close to last. And so in that case, if the project fails to meet its whatever its credit obligations are, or the timeline for development, and it simply runs out of capital and the banks are refusing to loan anything more, then it's very likely that this asset could just simply cease to be developed, and it would then go in the hands of any creditors and then eventually the equity holders. But the limited partners are going to have very little recourse to go after the developer, even if their name is on. I mean, look at the Trump case of the casinos, which have just all gone bankrupt in Atlantic City. Well, you're looking at, if you were a limited partner in that, you would say, well, I can go after Trump assets. It's just a name on a building, and in fact, there is no recourse against the developer. So I would say it's very unlikely, even in the case where you have a well-known brand name developer in the mix, that the limited partners are going to have access to the general, to the funds of that general partner.
Yeah, and thank you, Michael. And in the old days, we've been doing this work for some time. The issue was file your green card. Are you going to get your green card approved? And that's great. There really is a two-step analysis right now. The market has become more sophisticated. The Chinese market's more sophisticated. Not only does the investor expect to get their green card approved, but there is now also the expectation that 5-7 years down the road, they're going to get their money back, or most of their money back. So never before has this analysis become more and more important. The critical need to undertake sophisticated risk analysis and due diligence. This is the turf of Mr. Michael Gibson, and I think he does it well, but it's something that your clients absolutely have to do. We are focusing today on topics. We're going to jump around. I'm going to try and keep this conference relatively short and finish before 2. So, Michael, the SEC has outlined some guidance. The issue of redemption is a critical issue. We are seeing again the IPO has made clear pronouncements of what's an acceptable redemption. Mike, talk to me about redemption.
Right. Well, this was the well-known example in the market, which has been covered, quite extensively, was the Green Tech Automotive, and there was, I believe, some cases that were conducted at USCIS, which is, public record. But basically, what Green Tech had done, because Bernie, you're in China all the time, and the Chinese investor is very risk averse because they don't understand. They don't understand what exactly they're investing in. That's my sense. So they rely on these redemption guarantees, or these quote unquote contracts with the agents that their principal will be protected. And a lot of this is done under the table, on the side. It's definitely not allowed in the United States, but once you go offshore, certain things happen. I think this one, though, became very public because somehow it came out, it was in the offering documents, that this redemption guarantee was in there, and I think it caused problems for Green Tech, which may or may not have been subsequently fixed, but the note to everybody, I guess, who's doing the offering or the raise is be careful what your agents are guaranteeing, and especially if you put it in the offering document language, and Jor can address this better than I can, that it does not violate any USCIS provisions.
Jor, do you want to make, do you have any comment at this point on redemption, because you're the guy drafting a lot of these documents?
Yeah, we struggle because, what the law wants or requires versus what the investors ask for are two different things. And more importantly, on the subject of redemption, I believe that USCIS is a bit unclear on it. For example, if it's not just redemption, it's guarantee. If Mike Gibson gives me a loan for $100 and I have a loan agreement, apparently that's at risk. But if in the exact same document, Michael Gibson gives me that loan and says, I give you a loan of $100, Jor, and I guarantee I will pay it back, magically it's not at risk, even though in reality the risk profile hasn't ever changed. USCIS doesn't seem to appreciate that. So we struggle with that. Even Bernie's firm and us, and I have recently talked about redemption provisions because there was one investor that was very adamant on the deal to get guarantees and safety and get conversions into fixed market values, and most of those are going to end up affecting their immigration application. In that particular case, we were happy from the company's perspective to give anything that the investor wanted, because in our view, that deal was so safe they were willing to personally guarantee and everything. But in reality, it's what the investor really wanted. It was just possibly going to lead to a visa denial.
You know, there really is a catch-22 here. You're correct, Mike. You know, in China, the investors are always saying, well, what guarantee do I have? What assurance do I have? The Azumi decision is very clear. You can't give a guarantee. And so you have this contradiction where investors want to know, am I going to get my money back? And you have the entire program focused on this very, very clear, this comment here on redemption options. This is a direct a quote that I took out of the IPO Q&A. You know, it's very simple. There has to be a risk of loss and gain. If there is a promise to return or redeem some portion of the minimum required investment, you run into trouble. So these two critical points are not very confusing. They're quite simple. The reality is where we start getting lost, because at the end of the day, this whole concept, the Azumi concept, comes out of the fact that, you know, it is only through risk that you have job creation. And the more risk you have, the more jobs are created. I'm not an economist, so I can't comment on that. What I can comment on is that we have this catch-22 where the investor wants some assurance they're going to get their money back. And the law, which is very clear in requiring the money to be able to be lost and a profit to be made, which is kind of inconsistent to some degree with the idea of a loan. The loan implies, well, maybe that loan will be paid back, but remember, it's really got to be an at-risk loan such that it will actually create jobs in order to satisfy USCIS. So quite a dilemma that we have. I'm in the middle of Mike Gibson's analysis here, and he's pulled the green tech. For those of you who didn't follow it carefully, there was some linkage to Hillary Clinton's brother, who was a key executive. Anyway, we won't go into all the politics of the green tech fiasco. So, Mike, SEC has been kind of active lately, has put out an alert on scams. This again, within your specific framework, and some of the other comments that were made. I'm sort of jumping through your slides. Steve Cohen from the SEC. Mike, what's the SEC been saying and doing lately?
Right. Well, unless you just came in from the planet Mars, you probably know that the SEC is very involved, very active in doing a number of investigations. Subpoenas have been issued to regional centers asking for documents. No actions, as far as I know of, have been taken other than the obvious ones that you know, have been reported on recently. The Lee and Ken fraud that was, you know, they were indicted in Los Angeles. So we are all waiting to see, I suppose, what is their, what are they going to do? What's their next move? Because they have addressed the stakeholders several times, and they have said, you know, if you're, for instance, if you're in the business of transacting these securities, whether you're a regional center or you're an immigration attorney, and you are receiving commissions based on that, you should be registered. That's certainly, I think, the opinion of many people who work in the traditional financial industry and the financial service sector, that if you're in the business of raising capital and collecting commissions, you should be registered. Now, very few people in EB-5 are. So we don't know. I mean, is the SEC going to take action against certain individuals or regional centers? Or are they going to, you know, just issue a memo? Who knows? I mean, it's hard to say, but for sure, the word is out there that they're looking into this, and I guess for the people who are in the business of raising capital and earning commissions on this, they probably, to be on the safe side, should be registered either as a broker-dealer, registered rep, or perhaps an investment company. And you know, again, I defer to Jor to give us some color on that.
Jor, do you want to add your words of wisdom?
Yeah, I just want to stress, it's no joke. Maybe you haven't heard of, you know, what's happening because it's not really public in the press. But a lot of people have been getting subpoenaed. A lot of immigration attorneys that were improperly taking, you know, finder's fees, broker-dealer fees. You know, they all think it's finder's fees, but really it's not. It's a broker-dealer fee usually. You know, so a lot of them, you know, we know as a firm, just because we got, you know, there aren't that many firms that do what we do in the marketplace. So when subpoenas went out, we got a lot of phone calls, one after another each day, until all the subpoenas were out, and of lawyers and other people that were panicking because they had gotten this subpoena, even though we've been on these conferences for, you know, 4 years, warning them that this would happen.
So, Jor, I just wanted to ask the question, and many of the immigration lawyers, the analysis, at least up to 2010, 2011, you know, most of us lawyers, we understand ethics and we've taken ethics exams, is that the analysis was always an issue of disclosure. And many lawyers felt that, well, okay, regional centers pay a fee, a commission, whatever it is. This is kind of standard practice in the industry. And it's somewhat of a catch-22 because either the project is marketed in China and outside, in which case there's less SEC involvement, or, you know, it's marketed through immigration lawyers. Their clients come to them and say, you know, which projects do we choose? And it was fairly standard in the industry until 2010, 2011. I think at least I, for the first time, heard, wait a second, folks, this isn't an issue of disclosure that you are receiving a fee from a regional center. This is an issue, a securities issue. And suddenly immigration lawyers were sort of dumbfounded. What do you mean this is a securities issue? And it's only recently SEC has indicated that these are in fact securities. Obviously, to someone like you, Jor, who is a securities lawyer, that was perhaps a no-brainer. But to many immigration lawyers, they're still having trouble wrapping their heads around the fact that these are securities subject to SEC jurisdiction and not merely state bar and disclosure issues. So let me ask a question. I actually heard your partner say this, and I want to know if you stand by the statement and if it's true, is that the general idea was up until 2010, 11, maybe even as late as 12, some people were receiving commissions from regional centers, fully disclosing it to clients. Most people at that point realized this is perhaps not correct. It's got to go through, you know, registered broker dealers. They've got to have little numbers like Mike Gibson has their CRD number 157403 before they can receive commissions. And for those attorneys who sort of stopped the practice and you know, playing by the rules now that we know what the rules are, that should be okay. But those people who are still collecting commissions, whether or not it's disclosed to the client, may still have some SEC issues. Jor, is that more or less accurate from your perspective, sir?
Yeah, well, I think it's a matter of, you know, you've got laws, but in the U.S., you know, laws are only as good as how they're enforced. So if no one enforces a jaywalking law, then, well, you know, I guess you could break it, you know, with little consequence. So what we've observed is that there's too many people doing this for the SEC to probably go after everyone. And I think there's been at least one case that our firm knows of where there was a immigration attorney, a reasonably prominent immigration attorney in the space, who was illegally taking these finder's fees. But one day, their regional center contacted us and said, "Hey, you know, we want to do things right. Let's try to fix things." And that finder, that immigration attorney, took steps to do things correctly. Now, it turns out that later, that regional center got subpoenaed, and so did that attorney, for illegal broker dealing. However, it looks like in that particular case, the SEC chose not to pursue further because they saw that that immigration attorney proactively took steps to abide by the law once, you know, he or she knew about the law. And, you know, they could have prosecuted if they wanted to. You know, it doesn't mean that on a civil suit that a civil suit wouldn't have won, but, you know, using their discretion not to go after people that, you know, showed intent to abide by the law, they left that person alone. And if that's any guidance to, you know, other people who are still doing things the wrong way, maybe that's helpful. But technically, if you broke the law, they could come after you still. So I have to agree.
So the bottom line is, as immigration lawyers, we really need to be somewhat conservative. We need to be aware of these issues. But just being a little bit of a devil's advocate here, Jor, I'm even looking at this client alert dated December 2013, quoting Steve Cohen, who has really been, you know, out there in front speaking. I guess he was at the April 2014 IIUSA meeting, and also made this announcement at the Federal Bar Association meeting. And I'm just reading directly from the quote here. Blah, blah, blah. Where is it? Current editor was the message. It says, principal message was that the sale of interest through the EB-5 program could involve securities. Wait a second. Even here in 2013, there's a summary, and I'm not saying this is accurate, which is that it may involve securities. You know, isn't the fact today, and I think Michael Gibson will agree with me, and Jor, you will agree with me, this absolutely involves the sale of securities. Why? Just no?
No, because it depends. If
that word again.
Right. But for example, if I have a company and I go and raise money from EB-5 investor, it's almost always a security. You know, for everyone on the call, you should just assume it's a security unless it's not. So you know, don't even question it. However, if I created a company and my brother overseas invested, you know, as an EB-5 investor, and he took part in active management, like true active management of the company, not like an LP, but he was there running the business along with me, then he's a principal. He's not a passive investor. In that case, that would not be a securities, but it's still an EB-5 investment. So it's not 100% of the time it's securities. It's just 99% of the time.
Okay, but, you know, this is where the immigration lawyers start getting lost because, you know, securities isn't really an area that most of us are very knowledgeable. We're trying to share the information, and thank you, Jor, for confusing us with all this new stuff. But what we do need to know is what I think you just said is in most instances it does. This has been a wake-up call for many of us. The SEC has started articulating its position, and I think us immigration lawyers need to be very conservative. The idea of collecting commissions, you know, in reality, as an immigration lawyer, sometimes the employer pays my legal fees, sometimes the foreign national pays my legal fees, sometimes the benevolent next-door neighbor pays the legal fees, and we don't really worry. We know the obligation is to the client that we're filing, but who pays our fees and where the money comes from has never really been a big issue, other than from a disclosure point of view, where most state bars require us to disclose this to the client, that's kind of okay. But in the SEC context, we have to be very careful who we are taking money from, because it may in fact violate some portion of the SEC rules. I'm going to fast forward through some of your slides here, Michael. This was the case that broke very recently in Los Angeles. It's looking like a tough case. Immigration lawyers were in the lead here. I spoke to an immigration lawyer friend of mine, and they're like, wow, they got nearly 100 investors, almost a $50 million capital raise. I don't know the current information, but one of the attorneys currently detained in Korea, SEC all over one of the others. I was kind of surprised. I think I had heard the name. You'd think this is a small community, but these folks, it's not looking good for the program. Chicago was terrible, but the investors got their money back. We hope that this one has a good ending as well. And there it quotes Mr. Michael Gibson. I'm flying through these. So, Michael, I wanted to touch on the other topic, and I know I'm going to lose Jor in a few minutes. So can you briefly talk about what is this global insurance? The investor can, in fact, buy insurance through this company, and what is this all about?
Right. This has been floating around. It came to us a few weeks ago, and I consulted Dave Souders, who many of you will know from Todd Associates. He's my go-to guy on the insurance. And I asked him, what about this policy? And he did some investigation. We actually just got off of a call with one of the salesmen. And I'm not saying this is a scam. I'm not going to claim that. But I'm going to say, if anybody who is out there is either on a regional center side or has investors who want to buy the policy, you really have to do your due diligence, because we were not able to uncover a lot of significant facts regarding the ownership and operation, either online through researching online to the references that they make, contacting people that they mention in their literature, or even direct contacts with the company. So we understand that everybody wants insurance because they're concerned about cases like Lee and Kent, where there is fraud and they could lose everything. But this policy may not be your answer, and then the only guidance we can give you on this is, do your own due diligence and determine, is this a suitable product for your client?
And just because I'm an attorney as well, I'm thrilled to have someone like Michael Gibson here. He normally scares the hell out of me, and I can never sleep at night after spending time with Michael Gibson, because he reminds us all about the dangers and risks. And what he's basically saying here is you really need to check out, make sure the insurance policy. I certainly have very few skills in this arena of insurance. Obviously, if you can buy good insurance, that's great. The question is, can you buy good insurance? Jor, do you have any comment on the insurance question? We've seen it floating around for a while. I haven't examined any of the policies. I don't have any opinion one way or the other. Do you have any view on EB-5 insurance, Jor?
Yeah, we haven't yet seen anyone that we thought was a credible provider of the insurance, and that may just be because, EB-5 insurance is not a area of risk that people understand fully, and once they understand it, they might see that the risk is quite high. There are types of offering insurances that are out there generally, but to our knowledge, there's no one significant in EB-5 that that we know, has good policies and everything. And that could just be that we are ignorant of everything that's out there too, though.
Yeah, but you guys, we always at every single conference, and it's kind of, you go to any EB-5 gathering, it's they could round up the same gang. I don't think there's people sort of flying in, dropping in with major big secrets we don't know about. Michael, just to give you a little bit of a plug, this is your new project. You always have so many good new projects. What is this EB5projects.com?
Sure, Bernie, and I appreciate it. Basically, it's a database of hundreds of projects that have either been offered in the past for EB-5 raises or are currently in the market. For the attorneys out there who ask the question, what's in the market, this is a good place for you to go. And for the regional centers who want to put projects in front of investors, maybe not in China, maybe throughout the world, this might be a good place to get some attention. So what we're doing is we're trying to make the market a more efficient and transparent place for raising capital and giving information to investors. So for the buy side, for the investors, they can go on, they can check out videos, they can check out data, information about the regional centers and the members. On the sell side, they can put as much information in there as they want. We follow securities guidance that's been issued to keep your exemptions safe. So we're basically trying to create an efficient, transparent marketplace for everybody to come together and find out what's really true about these offerings.
So, Mike, sorry. Yes, Joel.
No, this is Jor. I got to say this is a great thing because, the EB-5 industry is now captured by a few gatekeepers, and there's not enough flow of the information. And, frankly, we're part of the problem, too. The fact that Bernie has Wolfsdorf has such a dominant, place in the marketplace, or that Homeier Law is such a dominant place in the marketplace, and Michael Gibson, that's part of the problem. But sites like EB-5, EB5projects.com really, help disintermediate all of us really a little bit. It's good for the industry.
Hey, Michael, did you pay Jor to make that comment? Wow. What do you mean, Wolfsdorf dominant? Not at all. Anyway, moving from the serious onto the silly, because we've been serious up to now. I have a 10-year-old son, which is my joy, and my wife's from China. She's often very serious and smart, serious, and beats me with a stick, etc. But sorry, not really. But so my 10-year-old came up to me and said, "Dad, we got to do the ALS Ice Bucket Challenge." And I'm like, ALS Ice Bucket Challenge? What on earth is that? And of course, it's exactly what he said. You pour a bucket of ice on yourself. So I went to my wife, and she's like, no, that's silly. You're not going to do that. So, Michael, what exactly is this ALS Ice Bucket Challenge thing here? And that is you in the red shirt together with my buddy John Pratt with Kurzban's office, and my buddy Gonzalo who runs a great regional center. What on earth is this?
Yeah, it was fun. By the way, before I forget, and thank you for the plug, every listener who's listening to your broadcast today, we'd like to give them free access to the portal. So you just have to send me an email, and I'll be happy to give you 1 month free access so you can check it out. On the ALS, yeah. So nobody in EB-5. I've been watching the news about all these different groups challenging. You've seen George Bush, you've seen LeBron James, you've seen all of the people on TV, very famous people doing. Bill Gates had a great one where he designed his own, dumper. But nobody in EB-5. And I said, you know what, this is a great cause. We need to start the ball rolling. I knew the conference call was coming up. So I got with John and I got with Gonzalo, and I said, hey, guys, let's start it in Miami and let's challenge a few people in the industry. If anybody wants to see the video, it's on eb5news.com. And we had so much fun, and so obviously I had to challenge my two panelists here, Bernie, you and Jor, and a big shout out to Cletus Weber up in Washington. So you three guys are my challenge. You can go on the video. You can see who Gonzalo and John challenged. And we had a great time. It was a lot of fun. And Bernie, you got 24 hours. Bernie, you and Jor both have 24 hours.
Well, there we go. I know I'm going to have to do it because when I put my 10-year-old to bed last night, I said, you know what, we got to do this. It's for a good cause, and a little bit of silliness, gets you through some of the craziness of this EB-5 industry. But there we had it. Michael, I'd love to get my 1 month free to this and go online and learn all about it. And here we go. Just because Jor's going to leave us in about 10 minutes, Jor really did something very helpful for this webinar on structuring case studies. Thank you, Jor, for putting this together. So let's talk about this, and let's run through these slides, and I think our audience will get a lot of value out of this presentation. Jor, take it away.
Yeah, so briefly, generally we talk about structures, and it's kind of an intangible discussion, and then we talk about general, kind of structures, and then, after the webinar, I get a few calls, and people say, I didn't get that. How does that affect me? So I thought today, instead of going through the general, we'd go through some case studies. And in general, for each one of them, we'll talk a little bit about whether it's a loan or equity model, whether it's a direct or indirect investment, whether, there's typically an escrow involved, what sort of redemption language you typically see in these types of deals, and then I'll show kind of the org charts for what they look like visually, and then maybe mention some of the required documents. So case study one is the simple case where an immigrant investor invests $750,000 to set up and run his own franchise, and that's key. And the structuring considerations are, of course, it's $750,000, so he hasn't invested $1 million yet. This means it has to be a TEA. So that's one structuring consideration, that the business has to be located in a TEA. And are securities involved? For himself, no. He's running the business. There is actually no securities. He's the principal of the business. If he gets other investors that are not running the business, then yes, maybe there's securities involved. Now, the corporate form. What kind of corporate form is correct for something like this? Well, in EB-5, you usually see LPs, limited partnerships used. On the East Coast, you see some LLCs used as well. But, really, that's just mainly people use those structures to get around the active day-to-day management requirements. But in this case, the EB-5 investor is running the business, so it really doesn't matter. He is going to control his business, and in this case, it's very likely that he forms a LLC or a C corp. It's almost always an equity model. It'd be very unusual in this case for an investor to do some sort of loan model here. And to be clear, and we could discuss this later if there's time, every EB-5 investment these days starts off as equity. It may be that the equity is then used and accumulated and converted by taking the equity investment and then investing into a loan, and that's what the loan model is. But every EB-5 investment these days starts off as some sort of equity investment into some company. In this case, they're setting up their own business. It's probably just equity into his own company. The job count for a small deal like this, it's almost always direct. It's feasible that a regional center is involved. It's feasible that they count indirect jobs. But for a smaller deal like this, they tend to just structure it with direct job counts. Obviously, in this case, they need franchisor approval. Because it's his own business, there's probably no need for an escrow. It's probably no need for exit strategy. His own exit strategy will be whatever it is, once he gets his green card approved and the I-829 finalized. And probably there's no need for a private placement memorandum because the PPM is really a disclosure document for other investors to protect the company. PPMs are not really for investors' protection. They're to give investors more information so they can make educated decisions. But companies like to give them really because they protect the company from the investors. So the structure here you see is basically the EB-5 investor owns the franchise company that he sets up, the franchisee company. And on the side, there's a franchisor. I just put that in there because they have to approve this. But it's very straightforward. You start a company, you own it. And that's case study number one. The required documents, of course, you've got that franchise agreement. You've got the company formation documents. You might have a subscription agreement. You might not have a subscription agreement. If it's a wholly owned company and you're the only, the EB-5 investor is the only owner, possibly it's just done while they incorporate. Of course, if there are other investors or other partners, more agreements would be needed. So that's the basic case. In reality, that doesn't happen too much in EB-5. Case study number two is where a immigrant investor invests $500,000 into a small direct EB-5 deal. And when I say small, I'm talking, $1 to $3 million, something where there's just a handful of EB-5 investors. Structuring consideration, same thing. It's $500,000 investment. It's a TEA. In this case, it's different. Because the immigrant investor is investing into someone else's project, this is a securities, and all the securities laws would apply. And also, the corporate form for these small deals, it's likely an LLC and it's likely an LP because issuers want to try to give the investors less say in their company. However, because they're small deals, it could be that it's just a C Corp. There's things that people can do to give EB-5 investors ownerships in corporations, yet not give them much control. So, in smaller deals, it is possible that it is some sort of corporation as well. It's almost always the equity model for the same reasons as case study number one. It's likely too small of a deal to get creative with the structuring. The job count is almost always direct because it's too small of a deal to really kind of involve a regional center and economic study and things like that, but it doesn't have to be. In the escrow, maybe there's an escrow, but in a lot of direct deals, smaller direct deals, we see that there is no escrow. Part of that may be because there's a closer relationship between the issuer and the investor by the time the deal is done. And more trust there, perhaps, and maybe the money's being used more quickly, and also there's less. Sometimes there's less concern about whether the project gets approved, because if the business plan is very clear, maybe the risk of proving the job creation and everything is a little bit less. Exit strategy, maybe. Sometimes the investors want an exit. Bernie's firm and us just recently talked about an investor that said, you know what, it's okay. They don't need their money back, but they want a real return in this business. They want to come in as if they were a U.S. investor. So we explored that possibility. A PPM, always recommended if there's an outside investor, but in a small deal like this, frankly, usually skipped. Usually the companies say, I know I have an obligation to disclose information to the investors. I will meet that obligation. I know I should do it through a PPM, but I'm going to choose not to. I'm just going to give them emails and phone calls and give them the information I think they need. Not advisable, but in reality, that's what most people do. The structure number two looks very, very similar to case study one, except for in this case, the entrepreneur is the owner of the franchisee company or the other company, and the EB-5 investor comes in as an investor into that other company. And the required documents for this, roughly the same as case study number one, but because there's securities now and because there's a third-party investor that's not yourself, there's typically investor questionnaire, a subscription agreement, possibly that escrow agreement, possibly that PPM. Now, the last case study that I'm putting up is what most people see. This is what regional centers typically use. This is what larger deals typically do. And this is a case where an immigrant investor invests $500,000 into a larger deal, 20 million, 30 million, 200 million, and it's typically a regional center deal. And the structure of it is where an investor invests into a company, and then that company makes a loan to another project, and that's very, very typical in EB-5. Structuring considerations, of course, TEA. Securities, almost always the case for securities here. The corporate form, almost always a LLC or LP, because there's just too many investors, and they're trying to avoid the day-to-day active management regulations. It's almost always a loan model in the EB-5 industry. Somewhere probably 85% and up of these deals are structured as a loan model. The job count for these big deals is usually indirect, so they'll count the direct, indirect, and induced jobs, and that's why the RC has to be involved. In these deals, there's usually an escrow, but it's usually one of those fake escrows that we talked about earlier, whereby there may be kind of early releases out of the escrow. The exit strategy, almost always there's some sort of exit strategy to the investors. Clearly they don't have a redemption right or a guaranteed return, but oftentimes it's communicated to the investor, even in the PPM documents, that the project has the option to kind of pay back after after the I-829s have been fully finalized. And in these cases, the PPM, if it's properly structured, technically not required, but almost always expected, almost always used in the large deals, and always a good idea. The structure for this is a slide you guys might have seen before if you've been on this. Is basically the capital raising entity, which is the entity whereby the investors invest into, is controlled by a general partner, which is usually the regional center or some sort of affiliate. Or, if the regional center is not at that level, then the regional center is involved through some other contractual arrangement. Then that capital raising entity makes a loan, and look at the red line down to the project company. They make a loan to the project company, and that's why this is called a loan model. And this is by far the most dominant structure out in the marketplace, or some sort of variation of this. The required documents for this, very similar to case study number 2. The company formation documents, the investor questionnaire, the subscription agreement, possibly an escrow agreement, almost always a PPM, and then of course, because there's a loan in this transaction, then a loan agreement.
Jor, thank you so much. It's 2 o'clock, and I know I have to release you at that point. You have very valuable information here on the Jobs Act. Maybe we'll cover that in the next one. I will give you another plug for this verifyinvestors.com. That is a website to ensure that people are accredited investors, and very, very important to make sure that people meet that requirement. Many regional centers are now using that website. I didn't understand your joke. Probably people don't understand my jokes, but we'll clarify that later. This Jor Law, despite his good sense of humor, is very, very smart corporate and securities lawyer. Thank you so much, Jor at homeierlaw.com. Call him, bother him. I do all the time. I bother him on a daily basis, and he actually gives me good advice, although we do tend to argue from time to time in serving the client's best interest. I'm looking at the clock. We've been going for an hour and a half. I've got a bunch of I just put too many slides into this one, but you can go online. We'll probably pick up some of this material in our next one. Jor, if there are questions for you, we may just have to skip them, or I'll take a shot at them, but I'm going to see what questions we have at this point, answer your questions as quickly as possible, and then I'm going to run. Jor's got about, he's sending me a message. I've got about 13 minutes. Wow, look at all these questions.
That's old. Bernie, I'm going to stop off now, but really quickly, I just want to say on the Jobs Act, in the past, people that were doing Reg D placements, they couldn't advertise. The Jobs Act changed it so that you could actually advertise and publicly solicit, which really makes EB-5 marketing that much easier. But there's certain conditions to that, namely that you have to verify that your investors are accredited, and that's what verifyinvestor.com does. But definitely for anyone that's structuring the EB-5 transaction, make sure, and most lawyers are not familiar with the new laws, make sure that they understand Reg D, Reg S, and the new Reg D as permitted by the Drafts Act. Just ask your lawyers that question. If they don't know what they're doing, find new lawyers. If they do know what they're doing, then make sure that you understand the new ways you could raise money.
Thank you, Jor. I really appreciate your valuable time. I'm going to try and fly through some of these questions. They look like a lot of them were focused towards you on structure. We may have to preserve them and use them for our next presentation. Those are the China issues, which I more or less covered, but we simply don't have the time to go into this. So, Mr. Technician, let's go to questions and see if we can. I always pride myself on getting through all the questions, but I got a feeling that today we just had too much material. Whoa, there we go. Question number 1, question for webinar. Total amount dollars you require clients to have ready and at this vote for all the expenses, including the invest involved in regional development targeted for EB-5 green card and 1 million investment for EB-5 green card. This is a kind of basic question. Number 1, remember the amount that needs to be invested is $1 million. That is the standard. That will be reduced to $500,000 in 2 situations. One is where you have a targeted employment area and you're at 150% of the national average of unemployment, and the other one is the rural area. So it's $1 million, only reduced to $500,000. We didn't get into those basic things. Let's go to question number 2. If the investor is a child who will use the parent's gift to invest in regional center, do the parents need to gift the $1 million as opposed to 0.5 so the child could be an accredited? This is another common issue, is that whether you can in fact have to gift the kid $1 million so that the kid qualifies as an accredited investor, or so you have to gift $1 million to the kid, and then the kid in fact invests $500,000. Michael, I'll ask you to jump in on this one as well. I don't think we have a clear answer on this one. I think it's untested at this point, but if the child is 17 or 18, which now may be the case with potential China back cutoff, we're going to be investing for children younger and younger. I actually had one today. What if a kid was under 16? Could they invest? And that raised the issues. Can they even enter into a binding contract with the parent co-signing? I'll try and answer the specific question here with regard to whether or not actually, I'll throw it to you, Michael, if you're still on. How do you feel about this situation where the parent gifts the child $500,000, the $500,000 is going to be invested? Can that child qualify as an accredited investor when they don't have $1 million and they don't meet the earning threshold? Can they just fill out Jor's website information and solve their problem? Michael, you want to take that one?
Right. Well, there's 2 tests that FINRA, and the SEC impose on investors. One is the accreditation, and they would qualify based on having the money in the account, but they would not qualify based on the suitability. And I think this is where we're going to see a lot of issues going forward as we get into litigation down the road, where you have people with money, but they were not aware of the risk. They were clearly not suitable candidates for the investment, either because, one, maybe they didn't have enough other resources. Maybe all they had in the world was $1 million, and they may not want to be in a limited partnership, illiquid condominium asset for 7 years. So there's a lot of questions, I think, that are going to be answered through litigation, but FINRA does impose a suitability requirement. And I would say, for the most part, the EB-5 investors that we see are not sophisticated, and there is a question whether they are suitable or not. I think that's going to be tested in the courts.
And the big bottom line there is that at the end of the day, if you don't meet the requirement, that contract is voidable, and that investor can get all their money back. Is that correct, Michael?
Right, and this goes to an earlier point that we were talking about, the risks involved with, paying immigration attorneys finder's fee. I agree with you and Jor that I think it was Jor who said it. I don't think there's going to be a lot of actions against everybody in the market who takes fees. The risk for the regional center operators is in paying somebody who's not registered. That technically could void the exemption, and I think you're going to find the same issue with the suitability rule, where they are in mass selling these securities, very complex illiquid instruments, to people who in the United States would not qualify. And I think there's going to be some question as to were these appropriate investments, and you're not going to test it until there is a negative outcome. So I think we're going to have to see more of these projects fail. But my sense is that once they start failing, there's going to be a lot of limited partners who lawyer up with litigators, and they go after the both the regional centers and the promoters who sold them what were ostensibly quote-unquote safe securities, and they're going to say these were anything but. They were highly illiquid, very highly risky securities, and I think there's going to be a lot of testing of this suitability in the courts going forward.
And I know we haven't given you a black and white answer to this question, because we're going to see this more and more, where the parent gifts the money to a child under the age of 21 so they can apply directly because of the China cutoff date. If you want to make sure that that kid is protected, you have that kid in fact be the principal investor, but then that raises the question whether or not you're going to lose your exemption by gifting that money to the kid. So complicated question. We have to skirt around the answer, but in as much as you can meet that two-pronged test, we're going to encourage it. Sorry, I'm going to try and fly through. We've got quite a lot of complicated questions here, and I'm going to try and give soundbite answers. For Chinese EB-5 applicant, will the child's age be locked at the time of filing the 526? And the answer is no, no, no. That's the whole big issue, is we keep hearing this, well, as long as the kid was under 21 at the time the principal filed, they should be okay. The critical question right now is how close to 21 was the child at the time of filing. So if you filed one day before that kid's 21st birthday, one day, and by the way, my September webinar, which I believe is recorded, you need to go back and listen to that, because I spent the whole webinar basically dealing with this very issue. The simple bottom, and it does take an hour or two to summarize it, but the one-liner here is that if you filed just before the kid's 21st birthday and the numbers are backlogged, the numbers are backlogged at the time of approval, you only get to deduct the time the petition was pending. So if that's not enough, and you want that time to be as long as possible, you want lots of RFEs so you can deduct lots of time. So if in fact China numbers backlog, you actually want case to take as long as possible to adjudicate, because you get as much, all of that time gets deducted from the kid's age to create an artificial CISPA age, or Child Status Protection Act age. This stuff gets super complicated, but the bottom line is if the backlog is much longer than the processing time plus the differential between the kid's birthday, 21st birthday, and the time of filing, complicated math formula, at the end of the day, that kid can in fact age out if the numbers are backlogged. If the numbers are current at the time of approval, which we're not going to see anymore unless President Obama gets bold and counts the total number of investors, not the total number of their family. Sorry, this stuff is so complicated, but the bottom line is the age is not frozen at the time of filing. So question for Michael or others. I'm new to EB-5. I have a question on the at-risk requirement which we are talking about, Azumi makes it clear that if there's a redemption agreement, debt arrangement, or promise to return, the money is not at risk. There are quite a few regional centers that are based on a pure loan structure, such as, and I won't quote them, how is that possible? Trust me, you know, I can't comment on this particular question, but it's not a pure loan. It's called a loan. The money is pretty much at risk, and you are pretty much going to be able to lose that money. This is the catch-22 that we were talking about earlier. Michael, I know I'm summarizing a very long question, but because this question really went to you, and I'm just summarizing it because I don't know if you can actually see these questions, but is this pretty much accurate? I mean, they talk about it alone, but the simple bottom line is, for this to work, that money has to be at risk, and you have to be able to lose that money, and that is, in fact, the reality of almost all the loans that we are seeing in the EB-5 industry today. Is that more or less accurate, Michael?
Right. From an analyst perspective, we view the risk involved in either the loan structure or the equity to be very similar, because at the end of the day, and I'm speaking strictly of private equity, where once the funds are raised and committed, really there's no recourse. I mean, they're either going to build the asset and it's going to be developed and it's going to be operational and cash flow producing as hoped for, or it's not, or some combination. But even a loan, and people, I run across this every day with immigration attorneys. They think because it's a loan, it's safer. And, you know, I have to disagree with them. I have to say, no, the only thing that has changed in this is that you have an exit date, a date on the calendar where you can look to for repayment. But the issue is, and we talked about this with the casinos, if there's not significant asset value to repay the loan, then your position becomes one of true equity. You assume the asset, and you're still in the same position as you were when you had the loan, meaning you own an asset now, but you go to the market, you try to sell it, as in the case of the meatpacking plant. You know, the limited partners assume control. They go, they sell the asset, and then they get the 10 to 20 cents on the dollar. So I guess, and I think you're right, we're not really answering the question, but the point is that whether it's a loan or it's an equity investment, a pure equity with no fixed exit date, the key question is, what is the value of the asset? That's the only thing that matters, whether it's a loan or it's equity. It really, to us, it doesn't make any difference, because if the value of the asset is low or less than the sum of the obligations, then whether you're in a loan position or equity, it doesn't make any difference.
Which is why, you know, we think of the word as a loan, you know, but the word loan implies some sort of a payback. But, you know, if it's an unsecured loan, then obviously there's not much obligation to, in fact, pay it back, because there's no remedy, there's no way to go after the developer. Jumping to another question here, if the developer/borrower has a redemption provision in the loan with a set premium, so here we have a situation of a set premium of 3% of the loan amount, so the total redemption price is 103% of the loan amount, would that satisfy the required potential for gain by the investor? Michael, you want to have a shot at that?
Oh, goodness. I'd almost want to leave that to somebody who is an expert. I just think any redemption agreement is going to be an issue. I mean, why? My point with these redemption agreements is, why even issue them in the first place? If the asset is a good asset, then you don't need it. Where people are issuing them is when the construct of this asset development, the structure, is weak. And so in order to make up for that weakness, they issue this piece of paper, which, you know, for me it's funny. If you gave me this piece of paper and said, oh, you know, Mike, I promised to repay you that loan, like Jor used the example before. This does not change the risk profile. All I have is a piece of paper. It means virtually nothing. What I think people need to really focus on is true asset valuation. If the deal is a good deal, you don't need redemption guarantees. Where we see them come in is on weak deals where they have to convince people that it's a good deal, and the piece of paper is not going to do that.
Michael, thank you. And it was unfair of me to throw that lawyer-like question at you because it's really something, Jor, I should take. You know, I'm going to say this is not legal advice, but if you really just look at the government's clear outline of what the petitioner must prove, the petitioner must prove a risk of loss and a chance of gain. You know, I'm not seeing a whole lot of risk of loss and chance of gain in this kind of analysis, and particularly when you look at it in the second prong of the government's framework, which is that there must be no promise or guarantee to return or redeem any portion of the minimum required investment amount. So I think the way that this is phrased in the question, it does present some problems. I really want to fly through each one of these questions. By the way, is probably a half-an-hour debate, but I want to kind of give you folks some answers and not give excuses. So questions re finder's fees. If the SEC does not enforce the law, state bar regulations mostly require disclosure of the referral fee to the client's right. Yeah, pretty much all the state bars do require disclosure, but the point that I made, which really was quite a discovery for me even 2 or 3 years ago, was that or at least the appearance that this is not merely a disclosure state bar analysis, but it's a securities analysis with regard to finder's fees. And the question is, you know, did you give the client a choice? Was it really a finder's fee? But the simple bottom line is, let's not assume that the SEC is not enforcing the law. That may have been the case in the past. Maybe there's a 5-year statute of limitations, but I think we have to be very conscious of the fact that the current SEC leadership is very focused on enforcing the law, and I think we need to be much more conservative than we had been in the past. Moving on to the next question, I might suggest that under the Jobs Act and with the proposed changes to the SEC rules, that most direct investments may not come under the review of the SEC comment. You know, I really need Jor to comment on that. You know, what I understand from having done panels with Jor is, you know, if you follow the Jobs Act very specifically, because it does put new onerous requirements on the parties, if you in fact comply with them, yes, it can be argued that maybe this does not come under the direct review. I think everything is under the review of the SEC, but you may not run afoul of them if in fact you comply with that very rigorous framework. And we will be sending out all of these slides to you. I unfortunately had to fly through some of Jor's 2 or 3 page analysis on the Jobs Act because we ran out of time. But I do encourage you to look at those very, very carefully. Let's see. I'm going to just finish off these last 2 questions. Is the investment advisor allowed to take a commission? The answer is yes. Yes. The registered investment, not just any investment advisor, one that is fully compliant with FINRA, with SEC, you know, somebody with the credentials that Michael Gibson has is legally entitled, I believe, working through the appropriate licensure framework, is in fact entitled to take a commission from regional centers. and this is still a standard practice to in fact pay commissions if you have the appropriate designation. Michael, am I more or less accurate on this one, sir?
Actually, I'm going to have to correct you on that one, Bernie.
Please do.
We're governed by different laws. I used to be a registered rep when I was at Citibank, and in that case, the Series 7, 79, or the 24, the broker-dealer, yes, they can take commissions involved in the sales of securities, but we are governed by a different set of laws and standards in which we cannot take the commission. So we're obligated to take typically what is a fee-only basis, and that's the structure we work under, where we charge upfront fees. They're not success-based fees. So one thing I would recommend all of the immigration attorneys who are out there looking for due diligence work to be done is to inquire whether the person preparing that is an actual investment advisor or not, simply because there is a question in our industry as to how independent people who take commissions are. And my sense is that when you do fee-only based work where you're doing the analysis and there's no outcome that could influence you to change that report, favorable or otherwise, that's probably a better report, or certainly a more fair report, than one that is generated by somebody who may be taking the sales commission. It's a completely different fiduciary responsibility to the investor. So the answer to the question is no. Registered investment advisors cannot take commissions. We operate on a fee-only basis. The sales reps can take commission, and it's a completely different set of laws, different examinations, and different fiduciary responsibilities.
Sorry about that, Michael. I knew at one point you had been a registered broker-dealer and working with a registered broker-dealer firm. Those are the folks who can, in fact, collect commissions. I apologize. I got that one wrong. We have a request here for a separate webinar just on the Jobs Act and marketing. That would be an appropriate topic for what is the scope of marketing. Many of these evolving issues, they seem to be very clear in Michael Gibson's head and in Jor's head, but not necessarily percolated through to the full market at this point to understand what the requirements are. I have a question for Jor. Unfortunately, Jor has gone. Let's try and preserve that question for the next one. I apologize, but no point in having us answer that one. So, folks, we've pretty much covered what is Michael's email address. Michael, do you want to just repeat your email address for this questioner?
Yeah, it's michael@usadvisors.org. For those that can't find it, just Google Michael Gibson, EB-5, or U.S. Advisors, and you'll find us.
Well, thank you so much, everybody. We've been going for nearly 2 hours today. We've had a very good attendance. I'm always amazed. Pretty much all of you stay on all the way to the end. Thank you very much for some nice comments coming along. Great webinar, Bernie, Michael, Jor. Thank you. We love compliments. Please do send them in. I need to please also encourage you to spread the good word about our webinars. We're getting registration in several hundreds, by the way, for every one of these webinars, so people obviously seem to be getting valuable information. And what can I say? The price is right, so we really appreciate it. Thank you very much for your informative sessions. We do appreciate positive feedback. Lawyers love a little flattery. Michael, thank you. Jor, thank you very much. And Wow, another one. Good job. Thank you. Well, thank you again. Have a wonderful rest of the week. And until next time, we look forward to speaking with you all. Not so many silly jokes today. Trying to keep on topic and look forward to speaking with you again. Thank you all very, very much for participating today.